paragraph 17 of my skeleton, substituting the names of the companies in this appeal.
How many other appeals are resting on this one?
Now, I don't know off the top of my head. I can find out the answer to that. I'm told there are a large number. We'll have to get back to you with that.
It doesn't matter the precise number.
Yeah. The first issue that was before the FTT in this case was whether the dividend that was declared and paid by Wynne Scarborough in respect of the shares held by the trustee of the trust was a distribution of a different company, Wynne Yorkshire, for the purposes of Section 383 Toya, Section 1000 of the CTA 2010. May I begin by looking briefly at the legislation that's relevant to this issue? The Lordships will find that in the authority fund behind tab 2, starting at page 5. And there we have section 383, which imposes a charge to income tax on dividends and other distributions from UK resident companies. And then over the page, section 384, tax charge is on the amount or value of the dividend paid or the other distribution made in the tax year. And then on page 7, section 385 tells you who's liable. And the person who is liable for any tax charge imposed under the chapter is the person to whom the distribution is made or treated as made, or the person receiving or entitled to the distribution. And I just ask at this juncture, Your Lordships, please to note the reference to the distribution running through each of those sections. So the charge is on the distribution. The amount of the charge is calibrated by reference to the value or the amount of that distribution, and the person who is liable is the person who receives or is entitled to that distribution. So there's a common concept of distribution that applies equally to each of those sections. Now, the definition of distribution is ultimately found in section 1000 of the Corporation Tax Act 2010, which is behind tab 5 in the authorities bundle at page 70. And for your Lordships note, we get there via section 989 of the Income Tax Act 2007, which incorporates by reference that definition. And if your Lordships have page 70, section 1000, behind tab 5, these appeals have focused really on B, but A is any dividend paid by the company, including a capital dividend, and B, any other distribution out of assets of the company in respect of shares in the company, except however much, if any, of the distribution represents repayment of capital on the shares, or is, when it's made, equal in amount or value to any new consideration received by the company for the distribution. And it doesn't matter, the tailpiece does, as it doesn't matter whether the distribution is in cash. Now, finally, we need to look at the definition of in respect of shares, which is behind tab 6, page 72, and it's supplied by section 1113 of the 2010 Act. And our focus is on subsection 3 of that particular section. For the purposes of this part, a thing is regarded as done in respect of a share if it is done to a person as the holder of the share or as the person who held the share at a particular time.
And that's the main issue on this part of the appeal, isn't it?
It's
accepted there was a distribution.
Well, it's accepted there was a distribution out of the assets of the company. The question is it in respect of shares?
Yes,
so
it's accepted, is it not, that your clients received it?
My clients received a dividend.
Yes.
And the appellant's case is that they received a dividend which was paid on the B share that was held in the trust. And that was a dividend of Wynne Scarborough. That was not a dividend of Wynne Yorkshire. And the question that's posed by this issue is whether that dividend, which is a matter of corporate form, and I think HMRC accept this as a matter of corporate form, was made and paid by Wynne Scarborough, can be treated as a distribution of a different company, being Wynne Yorkshire. So in a sense, Your Lordship's absolutely right. In terms of the legislation, that is the question. How does one answer that? Well, actually, the issue boils down to this in my submission. When one is analysing what is a distribution for these purposes, can one take a composite approach, sometimes called the Ramsey approach in tribunals below, and can one amalgamate several steps into one so as to arrive at that? Or does one respect the separate steps that have, in corporate law at least, a separate legal vitality, separate legal description? My overarching submission is that the latter approach is the one that was adopted by the Court of Appeal in Khan, and that Khan essentially says that when one is looking in this area, a composite approach is not the one that's adopted by this particular piece of fiscal legislation.
Can I go back to the answer you gave to my Lord a moment ago, that it was accepted that there is a distribution by Win Yorkshire?
There is a, if I go back to the definition of distribution in section 1000.
Yes.
Looking at paragraph B, is there a distribution out of assets of the company? Well, Win Yorkshire transferred money to Win Scarborough by way of a share subscription. So that is a distribution out of Win Yorkshire's assets. Question is, was that in respect of shares in Win Yorkshire?
Just to be sure I've got this right, what was distributed by Win Yorkshire was £200,000.
That's right, in return for a share.
The fact that it's in return for shares doesn't stop it being a distribution.
Well, it does,
Within the definition.
within the definition, no. Question is that in respect of the shares in Win Yorkshire? And in respect of means in this legislation a thing which is done to a person who is or was a shareholder. The appellant's case is the thing that was done was a share subscription. That was a transaction between Win Yorkshire and Win Scarborough. Now, the answer that was given by the tribunals below to the issue that was posed is the dividend that was paid, declared and paid by Scarborough, a distribution in Yorkshire for the purposes of section 383 was yes. And the basis for that answer, as I have trailed, was a so-called Ramsey approach or composite approach. That was the FTT's decision. The Upper Tribunal, as your Lordships have seen, effectively endorsed that. If I could very briefly look to the FTT's reasoning and then the Upper Tribunal's reasoning, and then it'll probably make sense for me to move to Khan, because that's the centrepiece of my submissions. With your Lordship's leave, I was proposing to look at the FTT's reasoning through the prism of the Upper Tribunal's decision, because it summarises it rather than moving between the two.
So we're going to the Upper Tribunal.
If your Lordships have that, yes please. So the key aspects of the FTT's reasoning are summarised in the Upper Tribunal's decision. And starting at paragraph 35, page 53 of the core bundle. There, as the Upper Tribunal rightly says, the FTT summarised its conclusion in paragraph 114 of its decision. That on a purposive approach to the construction of 383 to 385 and section 1000, on a realistic view of the facts, Win Yorkshire made a distribution to the appellants in respect of their shares in it by providing funds to Win Scarborough in the form of the funds used to acquire the shares in it, with the sole purpose of thereby enabling Win Scarborough to pay the B share dividend for the intended benefit of the appellants solely in their capacity as shareholders. So in the FTT's view, when Yorkshire subscribed for shares in Scarborough, it was making a distribution to the appellants. The Upper Tribunal notes in the next paragraph that the Tribunal's view, the FTT's view, this is on the third line, it noted that each of the steps of the transaction, if viewed as individual and discrete transactions, involve no pretence and had a legal reality, in the words of Lord Hoffman and McNiven, the question was whether on a purposive approach to the relevant provisions, the juristic analysis of each step should be respected, or whether the transaction should be analysed adopting a composite approach, having regard to the overall effects of the elements designed to operate together. And then in the extract that's set out at 37, just to pick out a couple of points from that, quoted text, paragraph 121 of the FTT's decision, the FTT held that the purpose, this is in the third line, the purpose of 383 to 385 as regards distributions is in broad terms to tax a shareholder on any value which a company delivers out of its assets into a shareholder's hands by some non-prescribed means, whether directly or indirectly, as a return on his shareholding, except where one of the specified exemptions applies. And then looking down to 122 at the bottom of the quoted text, really the final sentence there, to give effect to the true purpose of these provisions requires them to be given, as Lord Nichols put it in Scottish Provident, a wide practical meaning, which requires the tribunal to have regard to the whole of a series of transactions which were intended to have a commercial unity.
And that was expressly endorsed by the Upper Tribunal at paragraph 58.
That's right. So that's the question of what approach does one adopt here. And to be fair to the FTT, the Court of Appeal's decision in Khan hadn't been released at the time of its decision. So there's criticism from that point of view. Had been released by the time of the Upper Tribunal's the hearing of the appeal in the Upper Tribunal. So the Upper Tribunal does grapple with it, and I'll come on to what it says about that. Just to finish off on the FTT's reasoning. Paragraph 38 of the Upper Tribunal's decision. The FTT was clear that each step in the arrangements was implemented as part of a carefully constructed plan, with the sole objective of providing the funds to the appellants free of income tax. It referred to Lord Hoffman's statement in Carreras that a composite approach does not deny the existence or legality of the individual steps, but may deprive them of significance for the purposes of the characterisation required by the statute. Then the conclusion is at 127. So that was effectively how the FTT got to the answer yes to that issue. And the Upper Tribunal's decision was essentially to endorse that reasoning.
Yes.
Now, as I've said, the appellant's case is that something that's done in respect of shares is something which is done to a person in their capacity as shareholder or as former shareholder. What Win Yorkshire did was not in respect of shares. What it did was undertake a share subscription in Win Scarborough. Now, of course, that's having regard to the individual separate steps as a matter of corporate form. Counter point to that argument is the Ramsey approach.
Yeah.
And as your lordships have seen, my submission is that that kind of approach to this particular legislation is not what the legislation allows or requires. So if I could go to Khan then.
Just before we go there, can I ask you two things? First of all, did the Upper Tribunal correctly encapsulate the issue at paragraph 42?
Yes.
Yes. Secondly, if you're wrong on the Ramsey approach, are you saying that it was in some way misapplied by the FTT and or the Upper Tribunal?
The question is the question is simply...
So it's one of principle, effectively.
It's absolutely one of principle.
Yeah.
And in my submission, when we look at Khan, which is with the court's leave, is where I would go to next. In my submission, it's not possible to square a Ramsey approach in this case with what was done in that.
Right.
Khan is in the authorities bundle at tab 17. And rather unfortunate situation which Mr. Khan found himself. Because Mr. Khan had set about buying a company from its existing shareholders. And the company had about £2 million of reserves in it that the outgoing shareholders wanted to extract before selling. That's recorded at paragraph 16 of the judgment of Lady Justice Andrews, with whom the rest of the court agreed. So it was agreed that Mr. Khan would buy the entire share capital from the existing shareholders for an amount equal to the reserves in the company, plus an amount equal to the net book value, which was around £20,000. Then we're told that less than 40 minutes later, the company bought back all but one of the shares from Mr. Khan for a consideration that was equal to the amount of the reserves. And that left Mr. Khan with one share, and the selling shareholders with an amount equal to the reserves in the company. And that's expressed at paragraph 19 of the judgment. In reality, the reserves were paid from the company to Mr. Khan, who passed it to his solicitors, who passed it to the vendor solicitors. So via Mr. Khan, the reserves leave the company and they go into the hands of the exiting shareholders. And at paragraph 23 of the judgment, recorded that the Upper Tribunal found that the two transactions, the share sale to Mr. Khan by the old shareholders and the buyback by the company from Mr. Khan, which allowed him to move the funds into the hands of the outgoing shareholders, were agreed and implemented as one, having regard to their interdependency and the short time period over which they took place. At 25 of the judgment, it's recorded that it was common ground that the payment made by the company to Mr. Khan on the buyback leg, as it were, was a distribution that was chargeable to income tax under section 383. Fell within the meaning. So we have a situation where there's a clear plan to move the reserves over a short time via Mr. Khan to the outgoing shareholders. And had they moved the reserves out to the shareholders before the sale, it would have been a taxable distribution in their hands, subject to income tax. Now, HMRC notably didn't try to adopt a Ramsey approach to what had gone on there and try to combine those transactions into a composite under which the payment that travelled via Mr. Khan to the outgoing shareholders under the plan was treated as a distribution to them, which on one view it clearly was. What HMRC did instead was assess Mr. Khan to tax on the 1.95 million that he transferred within 40 minutes or so to the outgoing shareholders, on the basis that the buyback had been a distribution. So just looking only at the buyback leg. Mr. Khan challenged that assessment, arguing that viewed realistically, what had occurred was a distribution to the vendor shareholders, who were the persons who received and were entitled to the distribution. That is recorded at 31. The judgment.
Yes.
So the essential case is that what you have there is a composite. Effectively a distribution to the outgoing shareholders, and that the people who received and were entitled to the distribution were the selling shareholders. And to run that argument, Mr. Khan relied on a so-called Ramsey analysis. You see that at paragraph 43 of the judgment. And in a sense, that argument shares many similarities with the argument that's run by HMRC in this case and the answer that was given by the tribunals below to the issue that's posed. Mr. Khan's attempt was rejected by the court. If one looks to paragraphs 39 and 40, you can see the appellant's case encapsulated there. It was argued on behalf of Mr. Khan, this is paragraph 39, that the Upper Tribunal erred in law in refusing to consider the sale and buyback of the shares as a single composite transaction, and consider its overall effect rather than concentrating on the machinery by which it was affected, i.e. the legal steps of the chain. In substance and in truth, Mr. Khan was no more than a conduit for the selling shareholders to effect the buyback of the 98 shares themselves, and his intermediate role in that aspect of the transaction should be ignored. And then at 40, submitted by Mr. Sykes on behalf of Mr. Khan, that this analysis was unaffected by the fact that this was not a pre-planned artificial tax avoidance scheme, but rather a transaction comprising stages that had been structured in a manner designed to mitigate the vendor shareholders' tax exposure, in that it ensured that they paid CGT on the gain they made by disposing of their shares to Mr. Khan, which is chargeable at a lower rate than income tax. In terms of addressing that submission, Lady Justice Andrews, in her judgment at paragraph 49, page 364 of the authorities bundle, begins by looking at the UBS case. And in particular, refers to paragraph 68 of the judgment of Lord Reed in that case, which makes clear that some fiscal legislation requires one to adopt what might be called a composite approach, and some fiscal legislation does not. A Ramsey approach, which is an approach of looking at the facts viewed realistically and applying the legislation viewed purposefully, doesn't equate to a composite approach.
Sorry, I haven't understood. I thought you did equate Ramsey and composite approach.
No, that would be an error, my lord. Because
Right.
what Ramsey requires is a realistic view of the facts, to which is applied a purposive interpretation of the legislation. Now, that interpretation may lead one to adopt a composite approach, and it might not. There are examples of cases where it doesn't. Khan is one where it doesn't. So, Ramsey isn't a byword for composite. Now, I know in the tribunals below, the arguments are sometimes described as a Ramsey approach, as a shorthand for composite. But what's made clear in UBS is that that's not how Ramsey operates. Ramsey is a principle of statutory interpretation, yes, but it is not a byword for composite. You have to, it's always a question of interpretation. And that's the point that Lady Justice Andrews makes here. So then, essentially, the question that's posed is, what does this fiscal legislation require? And I don't think there's any disagreement between us on that. I don't understand the Upper Tribunal to have concluded differently. The question is, what was Lady Justice Andrews saying here when she said this legislation, or this is a case, perhaps even more specifically, where one does not adopt a composite approach? And the competing views are that Lady Justice Andrews had in mind only the phrase receiving or entitled to.
Well, that's what she says at paragraph 6, isn't it? Yeah. This case only concerns section 3851B.
Well, that's undeniably true. But as I endeavoured to show you, Lordships, at the very outset, one can't apply 385 without understanding what the distribution is.
But there wasn't any dispute in this Khan as to what the distribution was. It was common ground that it was the buyback, the premium paid for the buyback by the company, and it was the second of the two linked transactions. That was, I thought you showed us a paragraph in which it was accepted that was the distribution.
My understanding of what was accepted is that that in and of itself is capable of amounting to a distribution. But the very essence of the case being put by Mr. Khan was that one, if you like, elides the steps and views it for what it is, which is a plan to move the reserves out via Mr. Khan to the exiting shareholders. And that is a distribution to the exiting shareholders.
Well, yes, but it was paragraph 25 you showed us. It is common ground that the payment made by the company to Mr. Khan on the purchase of its own shares was a distribution under section 383. So that much was not an issue. What one was focusing on was the payment of 1.95 million from the company to Mr. Khan. question was who could be treated as receiving or entitled to it. As my Lord said, that's what Lady Justice Andrews identifies as the question under 3851B. In other words, as I understand it, this argument was not about an argument as what the distribution was, but who received it. Is that right?
It is undoubtedly a case which ultimately is about receiving or entitled to. But the essence of Mr. Khan's case was that you had to view the two elements of the transaction, the sale and the buyback,
Yes.
as a single composite step, as a
Yes.
single composite arrangement. Now, for myself, I don't see the point of that argument if it is not to say that that is a distribution from the company to the outgoing shareholders. There is no reason behind that argument if it is not to arrive at that conclusion. And when Lady Justice Andrews addresses the point 50 and 51,
Well, I think the point is really what Mr. Sykes is submitting at paragraph 39, when he says, at E, that as a matter of practical reality, the 98 shares were never Mr. Khan's to do with as he pleased, nor were the buyback process. He never had the benefit of nor control over that, and it was absurd to tax him on that sum. That's the point of the argument.
well, I think the argument is put in various different ways, but in terms of the composite approach, it is to allied those steps, the sale and the buyback, which puts reserves into the hands of the outgoing shareholders, and to say that that is the distribution.
Well, I think this is quite important to understand what Khan is actually about. But I have to say, I don't read paragraph 39, as my Lord has just referred to, as advancing an argument. Distribution was to the vendor shareholders, and they should have been taxed under the distribution code. I read it as saying the vendors sold their shares, and they were quite correctly taxed to CGT. The argument for Mr. Khan was, because you look at all the preordained steps together, when the 1.95 million was distributed to me, it wasn't my money because I had to use it, as everybody knew I was going to have to use it, to repay a loan which I had previously taken from the company to pay the vendor shareholders. In other words, it's not saying the distribution was really to the shareholders. It's saying the distribution, although to me, never became my money because I never had the use of it, because I was always going to have to set it off against the loan I'd already taken out to pay the shareholders, which is a different argument, I think.
Well, my Lord, I beg to contend otherwise, that if one looks at paragraph 31 of the judgment,
Okay.
21.
31,
31.
page 360 of the authority.
Yes.
There's a summary of the argument that's put before the tribunal below. Mr. Khan appealed unsuccessfully against the closure notice to the FTT on 2 grounds. He then appealed to the Upper Tribunal on the basis that the FTT erred in failing to recognise the true substance of the transaction, namely that it was a single composite transaction whose effect was to make Mr. Khan the owner of one share in the company devoid of its reserves at a small net cost. For the purposes of section 383 and 3851b, he contended that, viewed realistically, the persons who received and were entitled to the distribution were the selling shareholders, even though they no longer own the shares.
No, I accept you may well be right about that.
Well, and also if I can just show your Lordship paragraph 51 and 52 in Lady Justice Andrews' judgment, which has been the focal point of the battle. Paragraph 51, it is unusual for a taxpayer to rely on the Ramsey approach, which is generally invoked by HMRC when seeking to challenge artificial tax avoidance schemes, which this undoubtedly was not. However, the principles in Ramsey are of general application, and our focus must be upon whether the Upper Tribunal erred in refusing to look at sale and buyback transactions as a single composite whole, and if so, whether that led to their reaching the wrong conclusion as to who received or was entitled to the distribution. in my judgment, this is a case in which the legal nature of the transaction to which a tax consequence is attached does not emerge from looking at the connected transactions taken as a whole. On the contrary, the statutory provisions require the focus to be on the transaction under which the taxable distribution arose. However, even if one were to look at the transactions taken as a whole, they do not produce the end result intended for by Mr. Sykes, namely a distribution by the company in respect of its shares to the vendor or shareholders. So
Yes.
that is why I say that the central thrust of Mr. Khan's argument in this, at least it's being dealt with here, is about how one views the distribution. And as I said when I went to the legislation, it is essential to know what the distribution is, because that's what the charge attaches to. One has to know the amount or value of it in order to see what the quantum of the charge is, and then one has to see who's receiving or entitled to it to see who is liable. So always one has to identify what the distribution is. And what Mr. Khan's argument was doing here was trying to identify what that distribution is. And Lady Justice Andrews rejects that way of identifying it. Now, the Upper Tribunal in this case rejected that way of reading Khan. And if your lordships have paragraph 49 of the Upper Tribunal's decision to hand. The Upper Tribunal said that in its view there was nothing to support the interpretation that I've just put forward. And that when Lady Justice Andrews said in the passage that we've just looked at, this is a case, what the learned judge meant was that this was about receiving, the words receiving or entitled to, in section 385. And the Upper Tribunal also said that an approach to construing the chargeability provisions contained in 385 doesn't determine the approach to construing the elements of the definition of distribution out of assets in section 1000 or vice versa. That's at the end of paragraph 49. Now, in my submission, the Upper Tribunal erred in those conclusions. In terms of its interpretation of Khan, it simply doesn't fit with the arguments that were being advanced. The central premise of Mr. Khan's argument was about how one is to view distribution.
But in Khan, there was no dispute about what the distribution was.
Well, this is where, again, with respect, I don't agree, because where it's accepted that a buyback can amount to a distribution, because it is a distribution out of assets by the company in respect of its shares, because it's transferring money to a shareholder. What's being accepted there is, in principle, that amounts to a distribution. The question is that really the distribution here, when you have a plan to move the reserves from the company to the hands of the outgoing shareholders? Because it's difficult to fit any other analysis with what Lady Justice Andrews says about Mr. Khan's argument. And the punchline of it in 52, that the end result contended for by Mr. Khan is that you have a distribution by the company in respect of its shares to the vendor shareholder.
And is that, I mean, as you say, Ramsey is said to be a principle of statutory interpretation, which applies generally. So it's a question of how you interpret words in the statute. If you are relating the argument that Mr. Sykes was putting forward to the words of the statute, does it not have to come down to receiving or entitled to receive?
Well, it does, but I think the way it's put is the way it's encapsulated in 31. That you first of all in 31 of Lady Justice Andrews' judgment, you first of all identify what the distribution is, and then you ask who's receiving or entitled to it.
Yes.
And I think that the argument that was put was that if one views the distribution as being from the company via Mr. Khan to the outgoing shareholders, that's you drawing the dots. You say that's the distribution. Who received or was entitled to it? It was the outgoing shareholders.
I can see you could spin it that way. But if on the other hand you say, well, look, the distribution is the payment out of this sum of money by the company, now we have to ask where it's gone to. Then the argument becomes, on a Ramsey approach, asking who received or became entitled to receive it. Is it really Mr. Khan or is it really the outgoing shareholders? And at that point it becomes an argument about the interpretation of those words.
Well, as I say, undoubtedly, this case does boil down to, or at least in parts in the judgment, there is a detailed consideration of what's meant by those words. But that, with respect, my lord, that way of looking at it doesn't make sense of the argument that was being advanced by Mr. Khan, because why argue that the two limbs are a composite distribution when really the argument there is, I accept there's a distribution, but in reality, who's entitled to it? That's not the way in which it's put.
So just show me again. So 31.
So in 31, there's a summary of the way it's put.
Viewed realistically, the persons who received and were entitled to the distribution were the selling shareholders. Now, is that not consistent with a focus on the words of the statute about being receiving or becoming entitled to?
Well, undoubtedly it is, but it's important not to lose sight of the prior sentence, that the tribunal erred in failing to recognise the true substance of the transaction, namely that it was a single composite transaction whose effect was to make Mr. Khan the owner of one share in the company devoid of its reserves at small net cost. For the purposes of 383 and 385, viewed realistically, the persons who received and were entitled to the distribution were the selling shareholders, even though they no longer own the shares. And then there's also the point in 52 that the...
Just pausing at 31 for a moment. Does that not potentially make sense on the basis that the second sentence is explaining how the overall argument is put, and it's put by reference to be who received and became entitled?
Well, maybe, although the difficulty with that is why allied the steps. And the way that my submission will make sense of that is to...
So then moving, sorry, 51.
Yes, well, at 51 and 52, but really at 52.
52.
What's rejected is the punchline of Mr. Khan's case, that the end result is a distribution by the company in respect of its shares to the vendor shareholders.
But the facts found by the Upper Tribunal in Khan at 24 was that the payment of the 1.95 million by the company to Mr. Khan was a loan to enable him to acquire the shares, and his obligation to repay was then set off against the company's obligation to pay Mr. Khan. If he'd borrowed the money from the bank, and the bank required proceeds to be credited to his account, you wouldn't say the bank was entitled to the distribution, would you?
No, although that's one aspect of it, but you have to take into account that this is part of a plan whereby, I think in actual fact, the Upper Tribunal goes on to say the obligation to repay the loan is set off against the obligation to pay Mr. Khan, so it sort of disappeared through probably not even book entries. I mean, that was part of the overall plan. That I dare say that step could only have taken place if all the rest of the arrangements were also in place, i.e. that everyone knew that after you push the button, the end result would be outgoing shareholders get reserves, and Mr. Khan gets one share and it's worth 13,000 or 17,000.
Yeah.
So yes, although that's really a question of do you look at the separate legal steps or do you sort of ignore that as a sort of mechanism and look at the composite whole and look at it for its true substance. In my submission, in terms of its true substance, it's not very difficult to imagine a case where that's done and the revenue don't like it and they say that is a composite arrangement which put the reserves in the hands of the outgoing shareholders. It's a distribution. It's pretty naked. But the point is that's not the way it was looked at.
And just help me on the last sentence of 52, showing that I haven't got sufficiently in mind what the Court of Appeal said. So they say there that even if one were to look at the transactions taken as a whole, they don't produce the end result of a distribution in respect of the shares to the vendor shareholders. Where do they explain that sentence?
Well, there's
Yeah, I couldn't find it. I have to
no,
say.
there's. I'm not entirely sure where that's explained. I mean, it's also not fully explained why this is an instance of fiscal legislation which looks at specific steps as opposed to a composite approach. But it is clear in my submission that the basic argument that you can align these two things together was rejected. And it was rejected on the basis that this is not what this legislation does. And whilst it is true, as I say, that the ultimate focus was on who's receiving or entitled, to answer that question, you have to understand what the distribution is. And the court did engage with that when it said that is not how you look at this.
Yeah.
Sorry, is that quite fair? I mean, on the face of it, in this case, there wasn't a dispute about what the distribution was. It was about who received it.
Again, as I say, I respectfully can't agree with that, because if that was so, then I do not understand the case that's being put by Mr. Khan about eliding steps to view that as a distribution to the shareholders.
Why can't you express that in Ramsey terms by reference to who is receiving or becoming entitled to the distribution?
Because it necessarily involves a categorisation of what is the distribution.
But then how do you explain what Lady Justice Andrews says at 72? She says, in some cases, the identification of the person to whom the distribution truly belongs could involve having to stand back and look at the matter realistically, involving technical or artificial legal arrangements which might be put in place to obscure their identity. So she's not saying in all cases, is she, where the question who is entitled to the distribution is in issue, you can't adopt a Ramsey approach.
Well, there's a, with respect, my lord, but maybe a danger in using the label Ramsey approach in light
I'm sorry,
of the, well,
a composite approach.
yes, I don't. Para 72 is something that the Revenue relied on in their skeleton. They put the argument to the Upper Tribunal and didn't address it. But Para 72, I think, is saying that one can take a realistic view of the facts as to who in substance is entitled. I mean, it'd be rather odd to say this is an instance of fiscal legislation where you do not adopt a composite, and say, well, in some cases you would adopt a composite.
Well, what does 72 mean in that case?
In my submission, 72 is saying that there may be instances where one has to take steps to identify who, as a matter of substance and reality, is entitled, which is not the same thing as adopting a composite approach to what the distribution is. I mean, it's difficult to see how a provision can change its meaning depending on the case. The legislation has to mean the same in every case.
Yeah.
So it can't be a question of giving it a different interpretation. So with respect to the Upper Tribunal, it places a lot of weight on the words "this is a case."
Well, there are two parts, aren't there, to the Ramsey approach. One is the purposive construction of legislation. The other is the realistic view of the facts.
Yes.
And it may be that in paragraph 72, Lady Justice Andrews was looking at the second of the two components.
Well, that was essentially the submission I was seeking to make, which is that there's a question of looking at who in reality and in substance is entitled, which is not the same thing as looking at a composite approach to eliding steps to create a single transaction. I'm conscious of the time, but I have 3 more grounds of appeal to address.
Well, I mean, Khan is really the sheet anchor of your first ground.
Absolutely, it's the centrepiece of the submission. There's just one other point that I wanted to make about the Upper Tribunal's conclusions, because the Upper Tribunal doesn't just address Khan. The Upper Tribunal puts Khan to one side by saying, well, when Lady Justice Andrews said this is a case, it was about the words receiving or entitled. In my submission with respect to the tribunal, that puts a lot of weight on the words "this is a case," particularly when viewed in the context of the submissions that were being put and the legislation which has the thread of the distribution running through it.
Yes.
Which is a necessary precursor, and that links to the second point that I wanted to make about the Upper Tribunal's conclusion, where the Tribunal said the approach to construing the chargeability provisions in 385 doesn't determine the approach to construing the elements of the definition of distribution out of assets in section 1000 or vice versa. In my submission, that's wrong, because the question of what is the distribution and how one determines that has to apply equally to all of 383, 384, 385, and also section 1000, which supplies the definition of distribution. My Lord Justice Nugee is looking for those provisions. They were behind tab 2 and tab 5.
Sorry, where are we going?
Well, I anticipated that my Lord Justice Nugee was looking for...
No, I was actually looking at the definition of distribution because there's a point which is troubling me, and I'm sure there's a simple answer to it. The definition of distribution in section 1000, subsection 1 of the Corporation Tax Act, includes any other distribution out of assets of the company in respect of shares in the company. And then there's an exception, and one of the exceptions is when it's equal in amount or value to any new consideration received by the company for the distribution. Why was the buyback of shares in Khan not within that exception? The shares don't count as new consideration.
There are some rather complicated provisions that fill out those concepts. Payment of capital and new consideration, and they're rather detailed. I'm afraid I can't give the answer as to why that didn't apply in Khan, but I suspect it was looked at very carefully.
Yes, okay, thank you. Sorry, that was a red herring then.
The point that I wanted to make is just to go back to that thread of the distribution that runs through the sections. 383 imposes a charge on the distribution. As I've said, one has to know what that is to work out the quantum of the charge, and one has to know what that is to work out who is liable. So in other words, 385 is parasitic on the charge on distributions imposed under 383 and 384, and all of the provisions have the common definition of distribution in section 1000. So there are clear links between the provisions, and the meaning of the distribution as a term can't be different depending on which section you're looking at, because they operate together as a whole. And just finally, this is a point that's made in my skeleton and is addressed by the Upper Tribunal, but there is a difficulty in my submission in adopting the approach that the Upper Tribunal and the FTT have adopted in this case, in looking at these transactions in the way that it has as a whole, which is that it potentially gives rise here to what looks like multiple distributions of the same thing to the same people. So Wynne Scarborough declared and paid a dividend. So if Wynne Yorkshire has made a distribution to the shareholders, to the appellants, and Wynne Scarborough has made and declared and paid a dividend to the same people, then there would seem to be two distributions of the same thing to the same people. In my submission, that is a rather odd result that Parliament can't have intended, and it's a more important point more generally, accepting that this is a tax planning scheme. But if one takes just the plain vanilla case of a group where a subsidiary pays a dividend to its parent with a view to its parent paying a dividend to its shareholders, is that a dividend from the subsidiary to the parent's shareholders or not? And if not, why not? If one can elide these steps. And what about the dividend paid by the parent company?
Well, it's not so much eliding the steps. It's looking at the facts as a whole and disregarding those which are not significant for tax purposes. That's the Carreras approach, if you like.
Yes.
So your argument, this argument of yours, could be met by saying, well, the fact that Scarborough made a distribution to Yorkshire is not fiscally significant once you have decided that the real distribution was made to the shareholders.
But then how that, of course, requires one to identify when is a distribution real, or what amounts to the real distribution. Because if you had a dividend paid up by the subsidiary to the parent with a view, and this is common, with a view to paying the dividend ultimately out from the parent, is what's the real distribution there? And there's a plan. Money moves.
Sorry, just that's a development of an aspect of your vanilla case. Can I just understand how the vanilla case works? The parent makes a payment to the subsidiary with a view to the subsidiary declaring a dividend.
No, the subsidiary declares a dividend and pays it to the parent. The parent, with a view to the parent using those funds to pay a dividend to the shareholders.
So we ignore there's no role from the parent at the beginning. It's simply the subsidiary making a payment to the parent with a view to the parent paying its shareholders. It doesn't feel very Ramsey-ish.
Well, I dare say that's what everybody advising on the transaction would say. But that's usually because the corporate form of these things is respected. So where you have a share subscription, people don't think, maybe that's a distribution in respect of shares. But we've got to look further down the line and see what the purpose of this is. This is a world where the corporate form is usually respected. And you can see this in a sense in section 1000. They're quite specific transactions that are being looked at, and they have corporate form and corporate identities.
It does feel different when the parent is paying out money with a view to getting it to its shareholders, but it goes via the subsidiary.
But if one is eliding steps, and this is an area of legislation where one can do that, then what's the dividing line? I mean, a gut feel, I share, but it's not particularly helpful in terms of applying legislation. I just wanted to address what the Upper Tribunal said about that point. They didn't accept that point, but the reasons that it gave with respect don't meet the concern. It gave 4 of them. This is at paragraph 75 of its decision.
Paragraph 25?
75.
75.
First reason was that the tribunal said this was just in substance another way of presenting the argument that the scheme worked. Well, with respect, that's not the thrust of the point. It's the ultimate goal, but the point is about avoiding unintended consequences. Second, the tribunal says that the FTT didn't in fact determine that there were 2 distributions, but in the passage at section 114 of the FTT's decision, which is on page 50, you see it on page 58. The FTT said that the distribution was in providing funds to win Scarborough with the purpose of enabling the latter to pay a dividend on the B share. That would appear to contemplate 2 distributions of essentially the same thing. And at any rate, if the dividend that was declared and paid by Scarborough wasn't a distribution, it's not easy to see a legal basis for why. The third point that the Upper Tribunal made in respect of this submission was that the effect of a purpose of construction will depend on the facts. But again, that doesn't provide a satisfactory answer. Why is there one composite distribution in this case, but not in the vanilla type example I gave a few moments ago? What's the relevant factual difference? And then fourthly, the tribunal said that it's relevant that if the scheme worked, the dividend paid by Scarborough wouldn't be liable to income tax. I ask rhetorically, why is that relevant? The tax result should be the product of the analysis rather than the other way round. The tax result shouldn't drive the analysis. why should the analysis of what amounts to the relevant distribution depend on how much tax will be paid by the recipient? It's the cart before the horse with respect to the Upper Tribunal.
Can you explain to us why no income tax will be payable?
I'm so sorry.
Could you explain to us why, if the scheme worked, no income tax will be payable?
Because
When Scarborough makes a distribution by way of dividend to its own shareholders.
that's right. Well, that's right, but the share is held under trust, which is a settlement. The settlor of that settlement is
Win Yorkshire. So it's treated as Win Yorkshire's
It's
income.
treated as Win Yorkshire's.
Why does Win Yorkshire not pay corporation tax on income, but it derives
Because,
from a trust?
Companies don't pay. It's that the dividend is treated as the dividend of Win Yorkshire, and as a UK company doesn't pay tax on it.
A UK company doesn't pay tax on dividends
Dividends.
that it receives from its shareholders, from its subsidiaries.
That's right.
So going back to your vanilla example, where the subsidiary declares a dividend in favour of the parent who declares it in favour of its shareholders, there's only one taxable distribution, which is the last step.
That's ordinarily what we would expect. Yes.
Well, the payment by the subsidiary to the parent is not a distribution to the parent shareholders. Well, it's not a taxable distribution if it's going to the parent shareholders, because those aren't the subsidiary's shareholders. Is that right?
Well, it's one can imagine too much difficulty, variations to the example, but the question really is that two distributions or one? People would normally have thought that that was a distribution between subsidiary and parent, and then a distribution by parent to the subsidiary.
Well, it clearly is a distribution by the subsidiary to its parent. It clearly is a distribution by the parent to its shareholders. It might also be capable of being characterised as a distribution by the subsidiary to the parent shareholders, but that has no fiscal consequences at all, because that's not a distribution by the subsidiary to its shareholders.
Well, suppose this is where one. It's not uncommon to have joint ownership of the subsidiary, and there may be common shareholdings.
Oh, I see.
So that would not be that wouldn't be an answer to it. And ordinarily, everyone would say that's a distribution from subsidiary to parent, and then parent to shareholders. And the shareholders are not concerned in a tax sense with the distribution from subsidiary to parent. But if we can elide steps because step one is taken in contemplation of step two, then why doesn't that analysis flow? And these are things, understanding how this particular legislation operates is of considerable importance.
Yeah.
Okay, thank you.
Subject to the court, that was all I was going to say about ground one.
Right.
Can I move then to ground two? And this ground, as with grounds 3 and 4, all concern discrete questions of law arising under the Settlements Code. And ground 2 in particular concerns the interaction between the Distributions Code and the Settlements Code. Just in terms of how this fits into the overall picture. Ground 2 comes into play if, contrary to my submissions in relation to ground 1, it is right as a matter of interpretation and application of the distribution provisions to view the dividend paid by Scarborough as a dividend made by Win Yorkshire to the appellants. On the other hand, if the only distribution that's relevant here is the only distribution, in fact, is the dividend paid by Scarborough to the trustees under the trust, then it's common ground that falls within the Settlements Code. So that's how that fits into the overall picture of it. The Upper Tribunal upholding the FTT decided that the result of its decision that there was a distribution by Win Yorkshire was that that distribution essentially managed to fall entirely outside the scope of the settlement altogether, so as to bypass that code entirely. And the appellant's case, in essence, is that even if there was a distribution by Win Yorkshire, that distribution still arose under a settlement, so that those provisions are engaged. And in terms of what the tribunals below had to say about this, their reasoning is expressed quite pithily. Again, I propose to do this by reference to the Upper Tribunal's decision because it contains the relevant passages. If your lordships would look to paragraph 93 of the Upper Tribunal's decision, which is page 69 of the core. The FTT's conclusion and reasoning is confined to a single paragraph. It's paragraph 138. And the essence of it is that once it's been decided that a distribution has been made to the appellants, one ignores the settlement. So in other words, to give effect to the correct characterisation of the arrangements, i.e. as a distribution for tax purposes, the fact that Win Yorkshire declared a trust over its beneficial interest in the B share is to be ignored in the same way, for example, as the transfer of shares to an offshore entity was ignored in Furness, reference to Furness and Dawkins. In terms of the Upper Tribunal's conclusion, it's not quite, the reasoning is not quite the same, the conclusion is the same. That reasoning is set out at 96 to 98 of the decision. At 96, just at the bottom of the page, as the FTT put it, the income in dispute didn't arise under a settlement of which Win Yorkshire was the settlor. Its true source is not the settlement but the shareholding in Win Yorkshire. We considered that in that situation, although the FTT's reasoning was somewhat condensed, it was justified in concluding it was unnecessary to consider the settlements legislation. Mr. Jones asserted that the settlements code was prescriptive and took priority over other legislation. However, that assertion was not made good. Just moving to para 98. We consider that this ground fails for a more basic reason. That's because the dividend on the B share is not the same distribution in respect of shares by Win Yorkshire. Once the FTT had correctly found that under the distribution code there was a distribution in respect of shares by Win Yorkshire, that distribution could not be conjured away by the applicability of the settlements code to a different distribution. Just pausing there, with respect to the Upper Tribunal, the latter point is very difficult to square with the statement that it made in paragraph 79, that there was no finding that there were in fact two distributions on the facts here, one by Yorkshire and one by Scarborough. Here the Upper Tribunal seems to be saying there are two different things and it's wrong to treat them as the same. It's also difficult in my submission to square that statement with the conclusion on issue 1. Your Lordships recall the question posed by that issue was whether the dividend paid on the B share was taxable as a distribution made by Win Yorkshire to the appellants, and the tribunal below answered that yes, which implies that they were one and the same thing.
Well, they clearly weren't the same thing in one sense. They took place at different times. Win Yorkshire first transfers £100,000 to Win Scarborough, and subsequently Win Scarborough transfers £98,500 of that to the appellants. Yes. They're obviously different things at different times.
That is true, but it can depend on what the definition of the thing is. So if one adopts a composite approach, a distribution could take place in various steps over several days.
My understanding is that what's been decided by the tribunals is that when the money leaves Win Yorkshire, that's the start of a composite series of transactions which ends up with the money arriving at the appellants. the start of that is when it leaves Win Yorkshire.
Yes, I'd agree with that.
That's not the same thing as what Win Scarborough does, which is declare a dividend on its shares at some subsequent date, which is a step in the composite transaction, but it's not the same thing as the payment by Win Yorkshire, is it?
Well, that's exactly my case on ground one. It is a different thing, and your Lordship will recall that the definition of in respect of shares looks at the thing that is done and asks whether that thing is done to a shareholder. That in a sense, encapsulates my case about how one looks at those separate steps. But if one is taking a composite approach, then it is difficult to see that those two steps could be a distribution and a dividend as a separate thing, when the premise of their reasoning is that that is a single composite distribution. I mean, in any event, all I say is that that's rather difficult to square with some of the other things that are said in the Upper Tribunal's decision. That's not the thrust of the issue that I take with it. Before I address that reasoning further, could I just show your Lordships briefly the settlements legislation, which will then feed into this ground and ground 3. They are contained in Chapter 5 of Part 5 of Victoria 2005, which is in the Authorities Bundle at tab 3. Now, broadly speaking, this is a set of provisions which operates to treat income arising under a settlement as defined as the income of the person who created the settlement, who is then the settlor, and not as the income of any other person. Just starting at page 12 within the tab, there's section 619. That is the provision that creates the charge, the income tax charge. We're in tab 3, Lords, page 12. That creates the income tax charge on income which is treated as the income of a settlor as a result of section 624. That's the section with which we are concerned. Then over the page, 3 pages on, page 15, section 620, provides a definition of both settlement and settlor. Settlement includes any distribution, disposition, trust, covenant, agreement, arrangement, or transfer of assets, except that it doesn't include a charitable loan arrangement. And settlor in relation to a settlement means any person by whom the settlement was made. And then that concept is filled out by the following subsections. So a person is treated for the purposes of this chapter as having made a settlement if the person has made or entered into the settlement directly or indirectly. And then there's a particular expansion of that in subsection 3. And it's common ground, and it is well established that the courts have limited the scope of when an arrangement is classified as a settlement for these purposes to where there is some element of bounty provided. And the leading modern expression of that principle is the Jones and Garnet case, which I'll return to a little later. For your Lordship's notes, the relevant paragraphs are 7, 75 and 76. And then under section 622, which is at page 20, the person who is liable for any tax charge under the chapter is the settlor. And then page
622, did you say?
Yeah, 622, my lord, 622. Straightforwardly provides that the liability falls on the settlor. And then at 624, deals with a case where the settlor retains an interest in the settlement, which is page 22. It provides, and this is where I say the priority point comes in. income which arises under a settlement is treated for income tax purposes as the income of the settlor and of the settlor alone if it arises during the life of the settlor and from property in which the settlor has an interest. So there's a deeming which treats the income that falls within the scope of the settlement as being that of the settlor and the settlor alone. That is the essential operative provision within the settlements code. What this is dealing with, several different types, but the archetype is where, say, an adult who might be a higher rate taxpayer creates something like a trust in favour of their children, so that income producing assets are transferred into that trust to benefit the children, and that they would pay tax without these provisions at lower rates or maybe even no tax. And there'd be a mechanism for the settlor in that case to get the income producing asset back. And what the legislation says in effect is that you're treated as if you've never given that away. So that the income that arises under that settlement is your income. And so it overrides what would otherwise be the position, which is that it would be the income of the beneficiaries in that example. That's the archetype case.
How does that work if a settlor is a corporate body so it doesn't pay income tax?
Well, it's still treated for income tax purposes as being the income of the settlor, who's the corporate. The legislation has subsequently been amended so that corporates now wouldn't fall within that, the scope of that. But it's treated for income tax purposes as being the companies. The consequences that arise under the legislation. There's no real difficulty. I mean, that's the essence of the planning.
So you would say the life of the settlor in 6241 means the continued existence of the corporate entity.
Well, in the case of corporate settlor, yes.
But you showed us right at the beginning that the charging section 619, which says income tax is charged on income of a settlor under section 624. So if the settlor is a corporate body, section 619 says income tax is charged on their income. But they don't pay income tax. So the corporation's not liable for income tax, are they?
That's right.
So section 619 doesn't apply.
Section 619 imposes an income tax charge on income which is treated as the income of the settlor. 624 treats the income that arises under a settlement as being the income of the settlor and the settlor alone for income tax purposes. Now, in terms of the appellants, who are individuals who are subject to income tax, the income that arises under that settlement can't be their income because it's been treated as the income of the company.
So can I just probably confuse myself and everybody else, trying to understand how this could work in the case of a company. You explained that if a company receives a dividend from a subsidiary, that's not taxable. If a UK company receives a dividend from a subsidiary, that's not taxable. So if a UK company effected a settlement in favour of the subsidiary and then the subsidiary paid a dividend to the parent, that's not taxable. You're back at the beginning, so to speak. Suppose a UK company settled something on an entity other than a subsidiary. Then income received by that entity would be treated as income of the original company under the settlements code.
If what you had was a settlement which had been made by, or of which the settlor was the company, then yes.
But then if it's treated as the income of the company, it's not liable to income tax.
That's right, the charge doesn't apply to it, but under
And
the
if
code,
it's only the income of the company,
yes,
then the beneficiaries aren't liable
that's
for
right.
income tax either.
Well, they
Does
are,
that mean that nobody's liable for anything?
well, in essence, but that's because the code treats it as only the income of the settlor. So, and that's for all income tax purposes. That's section 641.
I think I'm struggling to keep up. Just so, suppose you have a company that owns an asset that's income producing. It wouldn't pay income tax on that income, but it might pay corporation tax on that income.
That's right.
So now, in some fashion, it settles that asset not on a subsidiary, but on some other entity. I suppose it doesn't make sense normally to do that, but for some reason it does that, so that the other entity receives the income on that asset. Under the Settlements Code, that income is treated as income of the original company.
Yes.
And subject to corporation tax?
Is your lordship there? I think I see where the confusion is. Your lordship's talking about an income-producing asset which is not shares, so the income isn't dividends.
Yes.
These provisions can apply to any form of income which
no, not quite.
Tax. So,
necessarily, well, if you're not paying the, if you're not transferring, if the asset you are settling, if the entity on whom you are settling the asset is not a subsidiary, then the income when it comes to you cannot be a dividend.
that's right.
But at any rate, so suppose in some fashion you a company settle an income-producing asset on an entity other than a subsidiary. The entity then receives income. That income is treated under the Settlements Code as income of the UK company.
Yeah.
And then subject to corporation tax because it's not a dividend?
I'm not entirely sure what the ultimate outcome of that would be, because the charge under the Settlements Code is a specific income tax charge, which applies in section 619. As to whether HMRC would seek to impose corporation tax on that on the basis that it's treated as the company's, I don't know the answer to that. There's certainly never been any issue in terms of these appeals as to whether the company could be a settlor, or whether, if it were right that the only settlor were Win Yorkshire, that the appellants would not be subject to income tax, which is really the focus of these appeals, because it's their tax affairs that we're concerned with. So I'm not sure I can give a categoric answer to your lordship's question.
Yes, I see.
It does seem quite a radical consequence, because if companies are only liable to corporation tax and not income tax, and all Section 619 does is impose a charge to income tax, not a charge to corporation tax, which it doesn't seem to do on its face, it would mean companies could avoid paying corporation tax on any income-producing asset by simply settling them. And then it wouldn't be anybody's income. It wouldn't be their income on which income tax was payable because they don't pay income tax, and it wouldn't be anybody else's income because Section 624 says so, which does slightly raise a question as to whether this code is intended to apply to corporate settlers at all. You say that's never been an issue?
It's never been an issue, and my understanding is the legislation now wouldn't have that effect.
I mean, for what it's worth, suppose a UK company settles the income-producing assets on a shareholder. That would raise the issue starkly, wouldn't it? I mean, the shareholder gets the income from the asset. It would be very odd if the shareholder could say, no, it's not to be treated as my income, it's to be treated as the company's income. And the company could say, no, well, it doesn't matter whether it's treated as my income or not, because I'm not subject to income tax.
Well, that's this case. Because Win Yorkshire settles the share in its subsidiary on which the dividend is paid on a trust, the beneficiaries of which include the appellant.
I suppose that's right.
So, the lordship says it's a start. I mean, this is exactly the point.
Say that scheme would be a much simpler one. You simply settle your income-producing asset on the individual, and the individual gets the income from it.
Yeah, I mean, I dare say that the people that conceived this saw this as the way in which it would operate, and that's why the planning's said to be. That's how the planning is said to work. So, absolutely, this case gives rise to that point, but it has never been in dispute that if Win Yorkshire is the settlor and the only settlor, then that would be the consequence. HMRC's attack on it has been taken various different forms, but it's either that it's a distribution straight out to the shareholders, not in the settlement, or if it is in the settlement, the settlors are the appellants, and the income is to be attributed to them. Now, the FTT concluded, of course, that the only settlor was Win Yorkshire, and it wasn't the appellant, which then, I think, necessitated the revenue changing tax slightly in the way that they sought to address those points. But that is the essence of how it operates. Now, the question in relation to ground 2 is whether, if there is a distribution that's made by Win Yorkshire, that can fall outside the scope of the settlement, so that one isn't concerned with those provisions at all.
The drafting of the settlement code seems to assume that the settlor is a living person. Not only is there reference to the life of the settlor in section 624, which we've looked at, but section 625, looking at retained property, disapplies subsection 1 on the bankruptcy of a person, not the insolvency of a person. So clearly that's referring to a natural person rather than a corporation.
See the point about the bankruptcy. And in my submission, there's no difficulty in construing the word life in relation to a company. It could be said to have
A life until it gets
hasn't-
wound up, until
and
it gets
exists.
dissolved.
But more critically, the legislation talks in terms of persons, not individuals. And usually when legislation wants to specify that it's a natural
Certainly.
person, it uses the term individual rather than the term person. I have to say I hadn't given any thought to the point about the bankruptcy, although I dare say that's not a defined term, and I dare say that if push comes to shove, you could construe that as insolvency. But as I say, that has never been an issue.
Yes.
Now, just coming back to this point then about is it within the scope of the settlement or not? The key question in my submission is really driven by the words of 624 sub 1, which is on page 22. The question is this income, the distribution, income which arises under a settlement? The FTT said, as you've just seen, well, we can ignore the settlement because we've got to give effect to the true characterisation of it. That's a distribution. It gets very muddy if we start looking at settlements, so we can ignore that. The difficulty with that is that it assumes that the legislation, properly interpreted, allows one to do that.
Just saying this a moment longer. So, if we assume you're wrong on ground 1, so under the terms of the other legislation, you have a distribution by Win Yorkshire to its shareholders. That distribution wouldn't be of income at all.
I'm sorry, I don't follow.
The payments by, well, you just tell me I'm wrong. The payments by Win Yorkshire to their shareholders are not of income. They are of income.
Yes, because it's a distribution, so it's an income.
Yes, I see.
An income distribution.
Yes, okay.
So the question is, does that distribution, which is an income receipt, does that fall outside the scope of the settlement?
Yes.
The FTT put it as a question of ignoring the settlement. The Upper Tribunal doesn't adopt that. The Upper Tribunal says the question is, what's the true source of this? The FTT's reasoning implies that as a matter of statutory interpretation, the distributions legislation somehow ousts or disapplies the settlements code, but on a proper interpretation of the law, in my submission, that is wrong. The question there is there anything in the legislation in the settlements code or the distributions code to mean that the settlements code has to yield where you have a distribution? And in my submission, there's nothing to suggest that. In fact, the position is quite the opposite. As I've said, the point of the settlements provisions is to displace the taxing provisions that would otherwise apply to the income in question, so as to tax the settlor alone. So the mere fact that it's a distribution can't displace the settlements code, otherwise it wouldn't work as intended.
And that, you say, that's the result of section 6241.
Precisely. And if that wasn't so, then it's hard to see how the settlements code would ever apply, because there's always an alternative tax charge. Now, the Upper Tribunal didn't agree with the proposition that the settlements code had priority, but in my submission that is the whole point of the code. In terms of the Upper Tribunal's reasoning and the question of source, it is true that all the income that would fall within the scope of the settlements code has a true source, in the sense of shares in the case of dividends, debts in the case of interest, trade in the case of trading receipts. They all have a source for tax purposes, but that's not the statutory question. The statutory question is this income which falls under which arises under the settlement? Now, the Upper Tribunal's reasoning seems to proceed on the footing that the arrangements involving the trust and the B share in Scarborough can be put to one side, but that's not consistent in my submission with its conclusion on the first issue, which is that the B share dividend was a distribution by Win Yorkshire. It's also not consistent with what it says about the scope of the settlement, which is that it effectively comprised every single step in the arrangement. If I could just show your lordships that briefly. In the Upper Tribunal's decision at paragraph 141, or bundle page 78. Your lordship should see there an extract from
Yes.
the FTT's decision, and at 222, subparagraph 1, in my view, the arrangement comprises at least the initial steps taken by Win Yorkshire to implement the planning, namely A, the establishment of Scarborough on Win Yorkshire subscribing for the A and B shares, B, the subsequent almost immediate transfer by Win Yorkshire of its beneficial interest in the B share to the trustees of the trust on terms that the appellants were the primary beneficiaries of the trust, and C, the subscription by Win Yorkshire for the additional A share for a premium of £200,000 with the expectation that Win Scarborough would immediately cancel the share premium created on the share subscription to create distributable reserves for use in paying the B share dividend, or at any rate the plan for that to happen. And in terms of the Upper Tribunal's comments on this, if your lordships would just move forward 2 pages to paragraph 146 of the Upper Tribunal's decision. This is in the context of trying to establish what the scope of the settlement is. So the upshot is really at 146 and 147. There's a consideration of how one goes about identifying what steps would have sufficient unity to amount to an arrangement for these purposes. And the tribunal says we find some assistance, this is in the 4th line, in the formulation suggested by Lord Walker and Jones of asking whether the relevant steps form part of a plan which existed when the structure was established. In the passage referred to above in Dunsby Upper Tribunal, Lord Walker continued, and for your lordship's note, this is paragraph 50 of the decision of the House of Lords in Jones. The planned result may be far from certain of attainment. It may be subject to all sorts of commercial contingencies over which the taxpayer has little or no control. But if the plan is successful and income flows through the structure which he set up, it is income arising under the settlement. And then in 147, at the end of that paragraph, the tribunal says, well, there are a number of different ways one might look at defining the scope of the settlement, but whichever one you adopt, the answer is the same. As the FTT found at 2224, all steps were clearly identified and planned from the outset. They were implemented within a short period of time. we consider that the arrangement comprising the settlement consisted of all steps in the scheme. So the basis of its decision is that the settlement, for the purposes of the Settlements Code, comprised all steps in the scheme, and that includes the steps which Win Yorkshire took that resulted in the dividend being paid on the B share to the trust. In my submission, it is difficult to see how the distribution can fall outside the scope of the settlement when that settlement encompasses each and every step in the making of it. In terms of the relevant statutory question, was there income arising under the settlement? To adopt the words of Lord Walker in the passage from Jones quoted by the Upper Tribunal at 146, income flowed through the structure which has been set up. It was therefore income arising under the settlement. And so it was within section 64. So in my submission, the Settlements Code is engaged, even on the conclusion in relation to ground 1, that there's a distribution from Win Yorkshire to the appellants. And one needs to go on to consider that code. Now, as I trailed, the FTT concluded that under that code, the appellants were not settlors at all, because they didn't provide any bounty for the settlement, and that the only settlor was Win Yorkshire. Consequence of that, when one applies the provisions, is that that dividend, that distribution, is not the income of the appellants. Now, the Upper Tribunal disagreed with the FTT's conclusion that the appellants weren't settlors, and that then takes me to ground 3, which is where I'll move next. Again, just to put this in context, ground 3 is a discrete question about bounty, about the requirement for bounty and what that involves. And it arises if your lordships are with me on either ground 1 or ground 2. If, on the other hand, the correct analysis is that the payment made to the trustees falls outside the scope of the settlement here altogether, then neither ground 3 nor ground 4 arises. Can I begin then by looking at the conclusions of the FTT on this point, because this is where, of course, the tribunals differed. And I will, I think, need to go to the FTT's decision here. That's in the core bundle, and if we could please go to page 175 of the core bundle. Paragraph 222, which sets out the FTT's conclusion on the application of the Settlements Code. And this is a passage that we looked at a few minutes ago. And there's the conclusion in sub 1 that there was a settlement comprising at least the initial steps taken by Win Yorkshire to implement the planning. But then over the page at subparagraph 5, which was not extracted in the bit, at least in that part of the Upper Tribunal's decision that was looked. There's a question of what comprises the arrangement, what comprises the settlement. But then sub 5, however, it makes no difference to my analysis whether the later steps are part of the arrangements or just the steps identified at 1. In either case, Win Yorkshire is plainly the settlor of the arrangement, as the party which entered into the relevant steps and or directly provided the funds required for the purposes of the arrangement, namely the cash resources it used to subscribe for the initial A and B shares and for the additional A share, and thereby provided an element of bounty in using its cash resources for the share subscriptions with the intention and expectation that the money subscribed to the additional A share would be used to fund the B share dividend, so creating income arising under the terms of the trust for the beneficiaries of the trust. And then at the following paragraph, the FTT states its conclusion that the appellants cannot see that the appellants can be viewed as the settlors of any arrangement comprising the planning or any part of it. And over the page to 226, please. Your Lordships will see that the FTT found that the clear intention of the appellants and expectation from the outset was that each step involved in this definite scheme, as Lord Walker described that term in Jones, would be implemented in order to deliver cash into their hands on what was intended to be a tax-free basis. Moreover, as a practical matter, the implementation of this definite scheme was entirely within the appellant's control. As HMRC submitted, the appellants were the controlling minds of Win Yorkshire and Win Scarborough, and their active participation was required for the implementation of each step involved as the sole directors of Win Yorkshire and Win Scarborough and sole shareholders of Win Yorkshire. But then the tribunal says at 227, this case has some features which are markedly different to the circumstances in some of the previous cases. And in those cases, individual settlors used a company to provide a benefit for others, namely their wife, their children, at least in part by using their own resources or endeavours, their earning capacity and the negotiation of a valuable deal, to generate income which they arranged to flow into the shares in the company held by or for the intended recipient of benefit. In this case, by contrast, the appellants as the parties who HMRC considered to be the settlors as directors of the relevant companies arranged for funds which belonged to another person, Win Yorkshire, and which were generated by in the usual course of its trading activities, to be provided to the appellants themselves, barring the minor sum paid to the charity in return to Win Yorkshire. And then at 228, finally, my view is that A, the fact that the funds belong to Win Yorkshire doesn't itself prevent the appellants from being viewed as having indirectly made a settlement, whether the arrangement constitutes the entire plan or only some of the steps involved in it, but is fatal to HMRC's analysis that under the planning, no material benefit. It is fatal to HMRC's analysis that under the planning, no material benefit was provided to any party. At sub 1 there, the tribunal states its view that an individual who is a sole owner and director of a company could be regarded as having provided funds indirectly for the purposes of the settlement if he or she arranges for the company to give the profits away. But then in sub 2, the courts have been clear and consistent in their view. The tribunal says that the settlement provisions apply only to a person as settlor where under the relevant arrangement that person is involved in the provision of an element of bounty. And the tribunal goes on to say that the appellants, however, whether directly or indirectly, did not provide to any material extent such an element of bounty under the plan. And then there's a finding that they did not intend to and did not in fact confer any benefit on any other person, whilst a small amount of the funds.
So what the FTT is saying is that the element of bounty test means a material element of bounty rather than any bounty, and that's where the UT disagreed. They say there is no test of materiality if you're just looking at the bounty element of settlement.
Well, essentially the FTT's conclusion in my submission, the finding, is that the appellants were self-interested. There was no gratuitous intent.
Yes, but
on their part.
there's no doubt that Cancer Relief got some money,
That's
and
right.
Win Yorkshire got some money.
Yeah, there's no doubt about that, and the FTT is alive to that. But
Yes, indeed. But so the legal test that the FTT is adopting was the element of bounty, such as it was, material, because they say, she says rather, right at the end of subparagraph 2, while a small amount of the funds were paid to a charity, that was simply the price which the appellants were prepared to pay for the receipt of the rest.
Yes, and I was about to emphasise that, because the flavour of that finding is that there was no donative intent at all. That was, insofar as the charity got something, it was just considered, in the FTT's words, the price paid for the receipt of the rest of the funds.
So how would you express that as a test?
What is a test?
So I set up a settlement under which, under the terms of the settlement, somebody other than me is going to get something. And somebody other than me isn't giving anything in return. How do you distinguish between between situations where there is an element of bounty and when there isn't? I mean, do you look at my subjective purpose in setting up the settlement? Well,
That's part of it. I mean, the sense that one gets from the cases, and I wanted to show you two cases in a moment, is that bounty is, in a sense, largesse. There's a gratuity to it. It's the provision of a benefit to others in circumstances where I think one could say there's gratuitous intent to benefit.
well, cancer research isn't giving anything.
No.
So why isn't there gratuitous intent so far as cancer research is concerned?
Well, because the finding is that was considered effectively the price paid for the receipt of the remainder of the funds. It was what was considered necessary in order to allow the plan to operate as formulated.
Well, that's just a piece of semantics, isn't it? In order for this scheme to operate, I need to give money to charity. Why isn't that giving money to charity? The reason I do it is that the scheme works.
It is, but that's not bounteous. That's
Why not?
Because bounty, as I submitted, bounty savours of largesse, gratuitous intent, where you benefit somebody for the sake of benefiting them. That is not the finding that's made here. The appellants are found to be effectively self-interested.
I mean, I can see, well, a test is it an arm's length transaction? Well, so far as cancer research is concerned, it's not an arm's length transaction. They're not giving anything.
Well, just on that point, my lord, if I may, your lordship says that's a test. That is not the test that is posed and the Upper Tribunal focuses on is it arm's length by reference to what's said in Jones and Garnett. But actually what's said in Jones and Garnett is it's a provision of a benefit by somebody that is not at arm's length. There's an additional aspect to it. So it's not just about whether you're acting at arm's length, it's whether there's a provision of a benefit.
But here there is a provision of benefit to cancer research, which is not arm's length.
But it is not. It's not considered bounteous in terms of. I mean, the question of what's bounty is not a sort of hard-edged scientific term. It's an evaluative judgment.
Depending on the subjective motivation of the person.
Yes, I think it has to be so.
Giving to charity.
Yes. Well, can I show you the cases that I wanted to show the court?
Yes,
I can make
of course.
submissions by reference to it, because the first case I wanted to show the court is Plummer. Which is taken as really the authoritative, at least the starting point for the authoritative recognition of the requirement for bounty. That's in the authorities bundle at tab 9. Decision of the House of Lords, which confirmed the requirement for bounty, and the case concerned a tax avoidance scheme that was entered into by Mr. Plummer with a view to reducing his liability to surtax by making certain payments to charity. And under the scheme, Mr. Plummer agreed to pay a charity £2,500 over 5 years in return for a payment from the charity to him of £2,480. So there was a net benefit of £20 to the charity under those arrangements. Now that's material in my submission for a point I'll come on to, but on the facts, the charity was getting something more than it was paying. It was held that was not bounteous, that was the Special Commissioner's view. It was also Lord Wilberforce's view. But it's not just a question of any benefit at all, counting as bounty. The revenue sought to attack the scheme on various bases, one of which was that the settlements legislation applied to it, so as to make the payments the income of the taxpayer. The majority of the House of Lords considered that the Crown's challenge failed because the settlements legislation only applied to transactions which included an element of bounty, and this one did not. If your Lordships would turn to page 115 within the authorities bundle, which is page 911 of the report, within the speech of Lord Wilberforce, at letter E, this is the point where Lord Wilberforce is considering the settlements argument, 911E, His Lordship considers the question of whether the definition of the term settlement in the legislation is to be given a literal reading. Because if it's given the full unrestricted meaning, the section would clearly cover the present agreement and would also cover a large number of ordinary commercial transactions. And then at G, Lord Wilberforce goes on, however, he says that you can't read in an exception in favour of commercial transactions, that's a F, but goes on to say that one still has to inquire what is the scope of the words settlement and settlor, and of the words which are included in settlement in the context in which they appear. If it appears on the one hand that a completely literal reading of the relevant words would so widely extend the reach of the section that no agreement of whatever character fell outside it, but that on the other hand a legislative purpose can be discerned of a more limited character, which Parliament can reasonably be supposed to have intended, and that the words used fairly admit of such a meaning as to give effect to that purpose, it would be legitimate, indeed necessary, for the courts to adopt such a meaning. Then His Lordship summarises the various types of arrangement that fell within the legislation. And that's over the page at 912 of the report. And then at letter D, holds that I think it can fairly be seen that all of these provisions in Part 16 have a common character. They are designed to bring within the net of taxation dispositions of various kinds in favour of a settled spouse or children, or of charities, cases in popular terminology in which a taxpayer gives away a portion of his income or of his assets to such persons, or for such periods or subject to such conditions, that Parliament considers it right to continue to treat such income or income of the assets as still the settlor's income. So just pausing there, a settlor is therefore a person who gives away a portion of their assets or income, in terms of that generalised description of what the legislation is getting at. And then just continuing partway through the paragraph next to letter E. These sections, in other words, though drafted in wide and increasingly wider language, are nevertheless dealing with a limited field, one far narrower than the field of the totality of dispositions or arrangements or agreements which a man may make in the course of his life. Is there then any common description which can be applied to this? The courts, which inevitably have had to face this problem, have selected the element of bounty as a necessary common characteristic of all settlements which Parliament has in mind. The decisions are tentative, but all point in this direction. The first clear indication of this was given by Lord Macmillan in Chamberlain and IRC, where Lord Macmillan said that he agreed that the settlement or arrangement must be one whereby the settlor charges certain property of his with rights in favour of others, must confer the income of the comprised property on others, for it is the income so given to others that is to be treated as nevertheless the income of the settlor. Again, just pausing there, there's a clear link between the settlor, the element of bounty, and the settlement. In other words, the settlor is the person who confers the settlement with bounty. Lord Wilberforce then refers to other decisions of the High Court which relied on the element of bounty requirement as a restriction. And then at 913 letter D, Lord Wilberforce concluded that the case before him, there can't be any doubt there was no element of bounty. The special commissioners indeed said that they regarded the transaction as a bona fide commercial transaction without any element of bounty. And as I said, on the facts in that case, just in terms of pre-tax sums, Mr. Plummer paid out more to the charity than he got back. Now, I dare say he did that because on a post-tax basis, he expected to be better off. But in terms of the pre-tax payments, there was a net benefit over to the charity.
There's also a timing issue. The £500 is payable over 5 years, and he gets the 2,480 straight away.
Well, that's true, and I wouldn't even attempt the calculations of that. But in terms of the basic arithmetic of it, the charity gets more.
But it can perfectly well be characterised as a commercial arrangement in the sense that mean, the charity, I dare say, wasn't a party to all this. Well, no, it must have been a party to this.
It was party to the...
Yes, so the charity is agreeing an arrangement under which it receives some money in return for allowing him to obtain the tax benefit. I mean, that's a deal.
Well, it explains why, on the face of it, the charity gets more than it pays out.
So it's a bilateral arrangement which doesn't have an element of bounty.
Well, there may have been a contract to it, but essentially what the FTT has found in this case is that you can explain what's gone on by reference to the circumstances, which show that what's happened isn't bounteous. It's essentially to benefit yourself. That's what the FTT is saying. That's why there's no bounty. Look at the arrangements as a whole, and they aren't bounteous. The second case that I wanted to show you, Lordships, very briefly, is the Jones and Garner case that I've mentioned once or twice. And really, all I need to show you, Lordships, is what's said in two places. There's a statement by Lord Hoffman about bounty, which has been taken as the authoritative expression of principle in the modern case law, which is at paragraph 7. Paragraph 7, behind
Yes.
tab 13, and your Lordships will have seen it set out in the Tribunal's decisions.
Yeah.
There's a reference to it being an old-fashioned phrase and so on. And then F, a donation to a spouse or child is traditionally expressed in a deed to be in consideration of natural love and affection, rather than the donor's bounty, nevertheless exactly the kind of thing at which the anti-abuse provisions are aimed. In Chin and Hochstrasser, Lord Roskill cautioned against treating the word bounty as if it had been included in the statute. Seems to me the general effect of the cases is that under the arrangement, the set law must provide a benefit which would not have been provided in a transaction at arm's length. So yes, there's a reference to a transaction at arm's length, but there's also a reference to providing benefit.
Can I just sort of clear them out of the way in my own mind, try two situations on your, as to which I suspect there are absolutely clear answers. First of all, husband and wife fall out. Divorce proceedings are brought. One spouse is in a position to claim financial relief from the other in advance of any court order or anything of that kind. The one spouse establishes a settlement in favour of the other spouse. Is that treated differently? Is there special legislation dealing with that?
I'm not aware of any, but I wouldn't like to categorically.
I mean, if it were within the scope of this scheme, well, we'll call him a husband. The husband is setting up an arrangement in favour of his wife, knowing that if he doesn't do that, he might be the subject of a court order requiring him to make provision for his wife.
Well, as I say, it's always a factually sensitive question. The punchline of my submissions on this point is that the FTT did not err in law, and if it didn't err in law, then what it's done is just identify on the facts whether there's bounty, and that is an evaluative question that's for the First-tier Tribunal to make. It evaluated the facts and it decided there wasn't an element of bounty. So it's always a factually specific question. I dare say that different minds could come to different results, or different conclusions in relation to the example that the Lordship has posited.
And just to try to clear another situation out of the way, suppose I set up a bare trust in my favour. Well, there's no element of bounty. Does that have to come within this scheme at all, or how does that work?
Would the bare trust come within the scheme?
Yes.
Well, I'd have thought the first point is that there's no element of bounty, so you wouldn't be within the scope of the settlement provision. But even if it were, the income would be treated as yours anyway.
So it simply doesn't matter.
For the purpose of the bare trust, it's
No,
as if it's yours. So I don't think that wouldn't be troubling.
Yes.
So in terms of Jones and Garnett, I wanted to show you Lordship's paragraph 7. I also just wanted to briefly show you Lordship an observation that was made by Lord Newberger at paragraph 83. Which is the comment that there's a reference to the judgment of Lord Justice Donovan. And then Lord Newberger says it's true that at that point Lord Justice Donovan was dealing with the question of the identity of the set law. However, the definitions of settlement in section 660G1, which is the immediate precursor to our rewritten legislation, and a set law in section 660G2 are closely connected, and it appears to me to be perfectly proper to rely upon observations as to what can be taken into account when considering who is a set law when deciding whether there is a settlement. So in my submission, the logic of that observation works in the other direction too. It's proper to rely on the observations as to what can be taken into account when deciding whether there's a settlement, when deciding who is a set law. Now, the FTT decided in the course of arriving at its conclusion that to be a set law, the person concerned had to have provided an element of bounty for the settlement. And that conclusion set out in the FTT's decision at paragraph 210, which is in the core bundle at 169.
This is of the FTT.
This is of the FTT.
Yes.
So here the tribunal decides that in order to be a set law, be somebody that's provided benefits that would not have been provided in a transaction at arm's length.
I'm sorry, which paragraph is that?
210,
Thank
it's
you.
core bundle 169. And then the tribunal there decides that it accords with the purpose of the provisions. And then at sub 2, I note that the appellants argued that a person may be a settlor even where he does not himself provide an element of bounty. As set out in Plummer is simply that the arrangement or settlement must involve the provision of an element of bounty, not that the settlor must himself provide it. However, A, that doesn't accord with Lord Hoffman's plain statement and the descriptions given in the cases of the underlying purpose of the provisions. B, in all the cases cited at the hearing in which the earlier settlements provisions were held to apply, the person who was found to be the settlor was also found to have provided an element of bounty. And then C, overall I find it difficult to see that on a purposive construction of the Settlements Code, a person can be regarded as having directly or indirectly made or entered into or provided funds for the purposes of an arrangement, unless broadly that person is involved, albeit an indirect involvement suffices, in the provision of an element of bounty. Now, in my submission, all those points are fairly made, and the appellants now support the FTT's conclusion on the point as they did before the Upper Tribunal. I'd also just like to add to the observation at C in 210 sub 2 sub C, the observation of Lord Newberger about the interlinkage between the definition of settlement and that of set law. And if a settlement must involve an element of bounty, then to make a settlement, one must provide that bounty, otherwise one hasn't made a settlement as that term is understood. So in my submission, the FTT's view is to be preferred to the tentative view that was expressed by the Upper Tribunal on the question of whether a person must provide some of the bounty in order to be a set law. The Tribunal did not express a concluded view on that.
Well, there are perhaps two questions. Was there an element of bounty?
Yes.
if so, who provided it?
Yes.
Now, the FTT decided there was no element of bounty. Sorry, they decided there was no material element of bounty.
By the appellants, from the appellants.
Well, they rather conflated the two questions. Because the Upper Tribunal's disagreement was over the question whether there was a requirement of a material element of bounty. That's what the Upper Tribunal say at 134.
So I think the way it unfolded was that the FTT decided that Win Yorkshire was definitely a settlor, and Win Yorkshire provided bounty. The FTT then went on to say the settlors cannot be viewed, the appellants cannot be viewed as settlors because they didn't provide any element of bounty, is the FTT's conclusion. And as part of that reasoning, the FTT concluded that to be a settlor, you have to be someone that provided bounty. The Upper Tribunal said in relation to the latter point, I've got hesitation in deciding that point. I'm hesitant to decide it. Some doubt was expressed, but ultimately a concluded view wasn't given. Because what the Upper Tribunal did was proceed on the assumption that was right, that you did need to provide bounty to be a settlor, and then said of the FTT's conclusions, the FTT erred in law in relation to its findings on that point as to whether the appellants did provide bounty. So
Yeah.
I hope that disentangles those different questions. Now, in terms of whether the FTT erred in its application of the bounty requirement, I've got 3 points. The first point is that, contrary to the Upper Tribunal's decision, which says that the FTT doesn't seem to have considered Win Yorkshire in all of this, because a small amount went under the trust of Win Yorkshire, that doesn't seem to have been considered, the Upper Tribunal says. Well, in my submission, the Tribunal had well in mind and applied Lord Hoffman's dictum from Jones, and we saw that at paragraph 210 of the FTT's decision, which I showed you lordships a few moments ago. The Upper Tribunal and HMRC on this appeal agree with that formulation. That's the Upper Tribunal decision at 133. So the FTT didn't err in that regard. It applied the right test, and in applying that test or that dictum, it was right to look at and assess what was provided and to whom. Secondly, Lord Hoffman's dictum refers to the putative settlor providing a benefit, and that concept, the idea of providing a benefit, implies provision to somebody else, not to yourself. And the FTT's essential conclusion was that they didn't do that. The appellants didn't do that, they were essentially self-interested. The Upper Tribunal said at 131 of its decision that the FTT erred because it arrived at that decision on the basis that the appellants were the principal beneficiaries under the trust, and there was a plan for most of the income to be paid for them. Paid to them. Now, that isn't, in my submission, the basis for the FTT's conclusion. The basis for the FTT's conclusion is the finding that the appellants didn't intend to and did not, in fact, confer any material benefit on any other person.
Well, that's because they inserted the word material. She inserted the word material.
Well,
She regarded the benefit, I mean, there was undoubtedly a benefit to cancer research. There's no getting away from that. But the FTT judge regarded that as immaterial.
Well, regarded on the facts, the appellants as not acting with any bounty, not conferring any bounty, if you like, not acting with any gratuitous intent. It's not just a question of identifying whether there's some benefit. There are commercial transactions where one party benefits more than the other. But that's not a situation of bounty. Bounty is used in the sense, as I say, of largesse, gratuity. And the
Yeah.
ultimate finding is that they did not intend to act in that way. They were self-interested.
Yeah.
And just to pick up on that point, as I said, the Upper Tribunal criticised the FTT on the basis that it said that it didn't appear to have considered the entitlement of Win Yorkshire. But that, with respect, isn't a fair criticism. That payment to Win Yorkshire is referred to by the FTT. Your Lordship's note, it's paragraph 227 sub 2.
Sorry, which one?
227 subparagraph 2.
Yeah.
So it was clearly alive to the entitlement of the company in that regard. Now, in light of it, the FTT's finding that the funds in question belonged to Win Yorkshire, it referred in the same paragraph to the payments to Yorkshire under the trust as a, quote, return to it of a minor sum. Now that may explain why it didn't see it as bounteous on any view, because simply returning funds to the owner isn't bounteous in my submission. But in any event, the tribunal was clearly alive to the payment and didn't consider that it was bounteous.
But in paragraph 2272 of the FTT, page 177 of our bundle, what's the explanation for the final parenthesis? Why does the FTT judge bar the minor sums paid to the charity in return to Win Yorkshire?
I'm sorry, my lord, the parentheses in
227 subparagraph 2. She excludes, bars, the minor sums paid to the charity in return to Win Yorkshire.
because in the preceding subclause, the FTT is talking about the funds that belong to Win Yorkshire that were generated to be provided to the appellants themselves, barring the minor sums paid to the charity.
Yeah.
So they weren't; those sums paid to the charity were not being provided to the appellants.
Right.
What that's qualifying is the provision to the appellants of the funds. So all that's saying is that there were minor sums that went to the charity and were returned to Win Yorkshire.
And then in 228, she goes on to say, it's in the rubric, fatal to HMRC's analysis that under the planning, no material benefit was provided to any other party. And she expands on that in subparagraph 2.
Yes, that's absolutely right. It's also
And that's where the Upper Tribunal disagreed. They said there isn't a materiality threshold. There's no de minimis threshold here.
yes, except that's what the Upper Tribunal said. Can I just also point out there 229?
229, yeah?
And 229 immediately following on from the subparagraph that the Lordship just referred to, that all the reasons set out above, at the most, the appellants could be regarded as having made a settlement for the purpose of the Settlements Code only in respect to the planning so far as it relates to the charity receiving the small sums it received, and for the reasons set out at 228 sub 2, I consider it doubtful that the appellants are to be regarded as having provided an element of bounty even to that extent. So, on a fair reading of the FTT's conclusions, the finding is that there was no bounty provided by the settlers whatsoever, by the appellants whatsoever, and the difficulty with the idea that the criticism that the FTT's applied a de minimis threshold is that it implies, of course, a conclusion that the sums in question were indeed bounteous, but that they weren't at a particular level so as to allow them to qualify. They were too small.
But surely the Settlements Code treats all the income arising out of a settlement as that of a settlor, whether the settlor has an interest in the income or not.
That isn't so, my lord, because under there's qualifications in section 624, I think it is, that requires the settlor to have an interest in the property in the settlement, which is then defined. There are more conditions than just having made a settlement.
And what do we make of the FTT saying that they consider it doubtful?
well, my reading of that is that they did not. It is not as though the FTT said, well, they provided bounty to the tune of £500, but I don't think that's enough. Which is what the Upper Tribunal's criticism implies they did, but they didn't do that. They said there is no bounty. It's not that it didn't hit the right level, it just, there isn't any. So it's wrong to say that there was a de minimis threshold applied. So, in summary, the FTT applied the right test and took the right approach and arrived at what is effectively an evaluative question of fact that the Upper Tribunal should not have interfered with. I respect this submission.
Right.
Subject to your lordships, that leaves me with ground 4,
Yes.
which concerns multiple settlors. And this arises if your lordships are not with me on seeking to uphold the FTT's conclusion that the appellants are not settlors at all. If they are settlors, then we're left with a situation where Win Yorkshire is a settlor, because that conclusion now is not challenged. And the appellants are also settlors. And we're also left with a situation, because of the FTT's findings, which are not challenged insofar as concerns this, that Win Yorkshire was a direct provider of funds to the settlement, and the appellants were indirect providers, or indirectly made the settlement. And if I could just show you the findings that set that out in the FTT's decision. I can do that by reference to the Upper Tribunal's decision. Just going back to that, Upper Tribunal, Para 107, page 71 of the court. I have shown you, your lordships, this before, so I'll take it briefly if I may. The finding at 222 sub 5 that's extracted in paragraph 107 of the Upper Tribunal's decision. There's the conclusion of the FTT that Win Yorkshire is plainly the settlor, entered into the relevant steps and or directly provided the funds required for the purposes of the arrangement, and thereby provided an element of bounty. And then moving forward to 109 in the Upper Tribunal's decision, on the same page, there's a reference to an extract of the FTC's conclusions.
Yeah, we just looked at that, I think.
I think we did. We certainly looked at it a few moments ago. The point that I take it from is on page 72 of the core 228 sub 1, that an individual who's the sole owner and director of a company in which profits have accrued in effect gives up the potential to receive those sums by arranging for the company to give the profits away. In both cases, on the natural meaning of the terms used, viewed in context, the individual may be regarded as having provided funds indirectly for the purposes of the relevant arrangement. So on the basis of those conclusions, when Yorkshire provides funds directly, the appellants would provide them indirectly. The same thing. Now there is legislation within the Settlements Code which deals with multiple settlors.
Yes.
I can show you that. It's behind tab 3. And you need to look to page 55. Please.
Sorry, which section?
It should be section 644.
644.
644, which is on page 55 behind tab 3.
Yes.
And now this provision, or its ancestor, distant, was introduced subsequently into the code because it was discovered that the code was ineffective where one had multiple settlors. And that's there's a decision of the High Court, which I'll show you, lordships, which which set that out. So these provisions, what has become these provisions, were added subsequently to deal with that. And the way it works is that the settlements legislation has effect in relation to each settlor as if that settlor were the only settlor. And the way that's said to work is by treating the property comprised in the settlement, references to that, and references to income arising under the settlement as references only to property and income originating from the settlor in question. That's subsection 3. And then section 645 on the following page supplies a meaning to the concept of property or income originating from the settlor. And so it specifies that references to property originating from a settlor are references to A, property which the settlor has provided directly or indirectly for the purposes of the settlement, property representing property so provided, and so much of any property which represents both property so provided and any other property as on a just and reasonable apportionment represents the property so provided. So there's a bit of a tracing following exercise that's anticipated by this legislation. So you can look at property that's been contributed to the settlement. You can also look at its traceable substitute, as it were. Now the key point here for the purposes of this ground is that this legislation, these provisions, anticipate, or they're drafted on the basis that, the plural settlors will have contributed different things to the settlement. What it doesn't do is address the situation where the plural settlors contribute the same thing, one directly and the other indirectly. So I suppose the question distilled into its essence here is, what does one do in that situation? And that gap has been identified before. It was identified in the IRC and Mills case behind tab 8. It's a settlements code case dealing with the child actor Hayley Mills. The question was whether Miss Mills was a settlor, and if she was, whether there were multiple settlors. It was argued on behalf of the taxpayer in that case that if Miss Mills was a settlor together with her father, they would both be said to have provided the same property to the settlement, and the legislation didn't provide an answer in such a case. And the position would be equivocal, and that was not acceptable. There's a summary of the submissions that we have in the law report, page 46, A to G in the report. I don't propose to go to that now unless your lordship would like me to, but there's a summary of the point that's made. Ultimately, the court doesn't have to address it because the court decides that there aren't multiple settlors, there's only one. But in the speech of Viscount Dilhorn on the very final page of the report, your lordships have that between E and F. It may be that a case will arise in which it can be said that income has been provided directly by one settlor and indirectly by another, in which case there may be a liability in respect of undistributed income falling on both settlors. What would be the position then has not to be determined in this case, or in this case it's clear that Mr. Mills is not a settlor affected by section 405(1). So the point's left hanging. Likewise, no answer was required in the case of Butler and Wilden case behind tab 11, which is a decision of the High Court, Mr. Justice Vinelot, who, coincidentally or not, had been counsel for the Crown in the Mills case. And in the course of the learned judge's judgment, page 37H, page 200 of the authorities bundle, 37 in the report, starting a few lines down in the final paragraph, the provisions which are now to be found in section 442, 442 is a predecessor to 644, were first introduced by section 20 of the Finance Act 1943 to overcome doubt that arose following the decision of Mr. Justice Macnaghten in Lord Herbert and IRC, whether in a case where there was more than one settlor, it was possible to tax either of them under the group of sections then contained in Part 4 of the Finance Act 1938, and so on, under which income arising under a settlement fell to be treated as the settlor's income, save possibly in cases where the income could be unequivocally attributed to one of them. Section 442 and its predecessor operate in this way. Under sub 1, if there's more than one settlor, section 437 must be applied as if each settlor was the only settlor. The remaining subsections then set out a code for discriminating between the income to be attributed to one and the income to be attributed to another settlor. House of Lords in Mills recognised the possibility that a case might arise in which income could be attributed under this code to more than one settlor, as it was provided directly by one and indirectly by the other, or indirectly by both, and that the section might then give rise to double taxation. This difficulty does not arise in the instant case because, in my judgment, the arrangement made by the taxpayers was clearly a reciprocal arrangement under which each contributed, whether by the provision of skill and services or by making temporary loans, the common purpose of providing the shareholders of the company, and so indirectly, and to the extent of their shareholding, the 4 older children with an income-producing asset free of risk and cost. So there are 2 cases where this issue has been identified, but it has not been necessary to resolve the point. In my submission, the consequence of such a gap would be either multiple taxation or multiple allocation of the same income to the plural settlors, or taxation at the discretion of HMRC. And neither of those is permissible, at least in the absence of a clear statutory basis. And there is a precedent for this, although not on this precise point. As was noted by the High Court in Butler, the ancestor of what's now section 644 was enacted because the High Court in the Lord Herbert case held that the settlement provisions couldn't operate where a given settlement had more than one settlor, with the consequence that no assessment could properly be raised on either. And that decision is in the authorities bundle in the final tab. It's a short but powerful judgment. Page 376 within the authorities bundle. The learned judge identifies that Lord Herbert is admittedly a settlor, but he's not the only settlor. His father is also a settlor. And just moving down between the 2 hole punches, the learned judge observes that the Act does not prescribe what is to happen when there is more than one settlor, and the question has never come up for decision. It is not suggested that all the settlors can be assessed in respect of all the income. That indeed would seem to be an extravagant proposition. Nor is it suggested by the Crown that the income should be distributed between them. In the course of argument, it was said that where there are 2 or more settlors, the assessment should be made on the settlor to whom the income would have belonged if the settlement had not been made. But that interpretation of the subsection is of no assistance to the Crown in the present case. And then moving on, the interpretation of the subsection put forward on behalf of the Crown was that where there are 2 or more settlors, the Crown has the option to assess any one of the settlors to the exclusion of the other, and that in the case of an assessment to income tax, the option must be exercised by the local inspector of taxes, against whose choice there would be no right of appeal by the taxpayer. While in the case of an assessment to surtax, the option would lie with the special commissioners. I find myself unable to accept that interpretation. It seems to me fantastic to suppose that Parliament has conferred on inspectors of taxes, or even on the special commissioners, the power to choose whether A or B or C should be liable to income tax or surtax, as the case might be. I therefore come to the conclusion that no assessment under the Finance Act 1938, Section 38, can be made on Lord Herbert during the lifetime of his father in respect of the income arising under the accumulation settlement, and that the decision of the special commissioner should be referred. So it was that decision which then gave rise to the introduction of provisions that did deal with multiple settlements. Now, the decision of Lord Herbert, or decision in Lord Herbert, I should say, was cited with approval by Lord Wilberforce in the Vestey decision. Now, Lords, I'm conscious of the time.
Yeah.
I did want to deal just with Vestey and then make a couple of additional points.
Right. How long are you going to be?
Well, I would endeavour to be, certainly try and be less than 10 minutes.
All right. Well, why don't you finish off now?
Grateful. Now, the Vestey case we have in the authorities bundle, behind tab 10, was concerned with the transfer of assets abroad provisions, and it concerned tax charges that were raised on UK resident discretionary beneficiaries under overseas trusts, where income had been accumulated and then paid out to the beneficiaries. The transferor in relation to those settlements was not liable for tax because he had no interest in the settlement. And the Crown had sought to assess the beneficiaries on the income arising to the trustees, even though the tax charge exceeded by some way the distributions that the beneficiaries received. And the argument of the beneficiaries was that the transfer of assets abroad provisions only applied to the transferor and didn't apply to the beneficiaries. If your lordships would turn within the authorities bundle to page 157, again, this is the speech of Lord Wilberforce. Between E and G, Lord Wilberforce tees up the question to be answered. And there's a question about how one interprets the legislation. That's not really the main focus here. The main focus is what happens if one can't interpret the legislation so as to avoid the consequence of the revenue we're arguing for. And at F, Lord Wilberforce says that the contention of the revenue is that in such cases they have a discretion which enables them to assess one or more or all of the individuals in such sums as they think fit. The only limitation upon this discretion is, they say, the total income of the foreign trustees may not be assessed more than once. This is a remarkable contention. Let us consider first some of the practical consequences if it is correct. Lord Wilberforce then sets out a number of consequences, and then over the page at D says that if they're applied to these beneficiaries, they are frightening enough, but there are more fundamental objections in principle to the whole proposition. Taxes are imposed upon subjects by Parliament. A citizen cannot be taxed unless he's designated in clear terms by a taxing act as a taxpayer, and the amount of his liability is clearly defined. A proposition that whether a subject is taxed or not, or if he is, the amount of his liability, is to be decided, even within a limit, by an administrative body, represents a radical departure from constitutional principle. It may be that the revenue could persuade Parliament to enact such a proposition in such terms that the courts would give effect to it, but unless it has done so, the courts acting on constitutional principles not only should not, but cannot validate it. And then there's a reference to the revenues contention that provided they don't collect more than the total amount of the income, they're entitled to collect it from beneficiaries as they decide. And Lord Wilberforce rejects that proposition over the page. Says, I also accept that they cannot, in the absence of clear power, tax any given income more than once. But all of this falls far short of saying that so long as they don't exceed a maximum, they can decide that beneficiary A is to bear so much tax and no more, and that beneficiary B is is to bear no tax. The fact is, in the present case, Parliament has laid down no basis on which tax can be apportioned where there are numerous discretionary beneficiaries. And that, I say, is what would happen here if the conclusion is that the appellants are settlers along with
But suppose that were to be the conclusion. Lord Wilberforce ends up by saying the tax must fail, top of page 1174. Applied to this case, would that mean that the Settlements Code doesn't apply, and we therefore go back to the Distributions Code?
that the Settlements Code would not apply. Effectively, that the Settlements Code would apply on its terms, but that there is no means of allocating the income as between the settlors. It doesn't completely throw out all of the code. It's that there is just, in terms of constitutional principle, there is no proper means of assessing the individual settlor.
So nobody's liable for anything?
Well, that would be the consequence.
Okay.
I mean, that was the consequence in Lord Herbert.
I mean, just looking on in Lord Wilberforce's speech, this is 1174G. He says the result of the preceding argument is that if Congreve is correct in this respect, a result is produced in the case of discretionary trust, which is arbitrary, unjust, and in my opinion unconstitutional. That must cast doubt on the decision, blah, 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 blah. If one interpretation produces such a result but another avoids it, the latter is to be preferred. Then he says there are undoubtedly two possible interpretations. So he then chooses between them.
Yes.
So he is relating his conclusions to what Parliament has said. So coming back to the Settlements Code, how do we relate the problem you're identifying to the construction of the Settlements Code? It is not invested, they say, well, it can't apply to discretionary beneficiaries. Do you say it can't apply to those who provide indirect benefits to settlements, or what is the statutory interpretation that you favour?
Well, it's important to, in terms of that question, understand the broader context of Vesti, because what had come before the House of Lords was also a question of whether they should overrule a previous decision of the House of Lords in Congreve, which held that you could apply those provisions to beneficiaries. And effectively, they come and revisit that question. And Lord Wilberforce's decision is that they should overrule the decision in Congreve on the basis that you would interpret the legislation so as to avoid that result. So there's an overlay to that question, which in my submission doesn't apply here. Where one would end up is the situation that applied in Lord Herbert, which is that no assessment can properly be raised. There is no interpretive way out of it.
That's not the Vesti route. In Vesti, they do interpret the legislation.
Because there was a means by which that could be done. But in Lord Herbert, there was no interpretive way through that. The conclusion was that you cannot assess. And likewise here, there is no interpretive route. You're left in the position effectively as applied before the enactment of the provisions that were introduced to try and deal with the concern that was raised in Lord Herbert. There's a gap, in essence.
Which is a bit odd when there's no gap in the terms of the legislation.
Well, there is, in the sense that there's nothing in the legislation that deals with the situation where you have provision of the same thing directly and indirectly by different people.
But superficially, I mean, subject to all your other arguments, you've got a situation where each person is liable under the terms of the legislation. There is no gap. There is double taxation. In Vesti, to avoid that sort of problem, they find an interpretive solution.
Well, on the question of double taxation, which is the Upper Tribunal's route out, which is to say, well, Section 644 and 645 would give you double taxation, and that's what's contemplated as being the answer in Mills. First of all, in my submission, that's not a fair reading of Mills. The argument is posited in Mills, and it doesn't have to be dealt with.
But on your case, it would have had to be dealt with. Because if there was the potential for double taxation, then nobody could be liable.
Well, with respect, my lord, no, because there had to be more than one set law for the argument even to arise, and the conclusion in Mills was that there was only one. So that's why the argument did not arise. It didn't become necessary to decide it because there wasn't a multiplicity of set laws. The point is raised in Mills, but double taxation is not posited as an answer. That's posited as a problem. Now, in terms of double taxation, I'm going to deal with this very shortly, but in my skeleton, I've made reference to various decisions, including the House of Lords decision in Edison, which is in my paragraph, in my skeleton at paragraph 73.2. And what one gets from that, and the case law related to it, is that there's an interpretive presumption against double taxation. But it's a presumption. It can be rebutted. And if I could just very briefly show you in the authorities bundle at tab 12, within the speech of Lord Bingham. Lord Bingham was in fact in the minority in this case, but there was agreement across the committee as to this point about the presumption of double taxation. The question is how it applied. In paragraph 3 of Lord Bingham's speech, which is page 207 in the authorities bundle, the reference to the presumption against double taxation. But that's not conclusive or irrefutable. Parliament is sovereign. Since, however, the presumption exists, like the presumption against double taxation, for the protection of the citizen and operates to curb the power of the state to exact payments from the citizen, the presumption will be displaced only if sufficiently clear express words are used, or there are circumstances surrounding the enactment of the particular legislation which lead to an inevitable inference that Parliament intended in using the words that it did, that the presumption should be displaced. I did not understand either party to question the correctness of the approach indicated in these quotations from the opinion of Lord Oliver in Woolwich. So there's a presumption, it's rebuttable. You can rebut it with clear words or looking at the surrounding circumstances. Now, in my submission, looking at the legislation that we have, there are no clear words that authorise or require double taxation. And if one looks at the surrounding circumstances that were in play when the ancestor of 644 and 645 was enacted, it was precisely to prevent double taxation, not to create it. So the idea that 644 and 645 should be interpreted to lead to the conclusion that Parliament intended double taxation, in my submission, is without foundation. The provisions exist to avoid it.
So is the consequence of your arguments under this head that there can't be multiple set laws of the same property?
Well, they can be, but there's no allocation to them under the provisions.
But is your interpretive solution that you must choose the direct provider over the indirect provider? Or do you say that if there are multiple set laws under the same, or of the same property, neither is liable, even though one has provided the property indirectly and the other directly?
That's the conclusion of Lord Herbert, is that neither can be assessed because the legislation doesn't deal with them.
But nevertheless, the settlement code applies.
But there's nothing to displace the settlement code. It's that they can't be assessed. It's a constitutional. I don't deny it's a big point. I mean, these are fundamental points, but there's precedent for them.
Right.
Unless I can assist further, I encapsulates, I think, my ground before. I've taken up more time than I had anticipated, so I'm grateful for your very important.
Thank you very much. Would it inconvenience you if we started again at 2:05? 2:05.